name shit, that shit hasn't, I'm not that name argument stopped working about 10 or 15 years ago. It's been a long time that hasn't been working. A long time. So if somebody's still out there telling you to do that, they don't know what they're talking about. They're listening to some old information. They don't know what they're talking about. I understand what you're trying to do is you're trying to separate yourself from the straw man, to let the people know that you're a real living soul, and that is the straw man. And there are many different creative ways of doing that, from signing your name, how you sign your name. But at the initiation of a proceeding, don't make that much of a big argument about the name. It's not so much of the name, but it is the office the name is occupying. Are you a beneficiary or a trustee? Do you have all the liability? You're making a special appearance. Making a special appearance means you're not subjecting yourself to the jurisdiction of the court, that you're here to contest that there are matters that need to be discussed, which at that point, I'm going to immediately go into my dialogue about, hey, look, Your Honor, when you ask these people this question, I'm going to tell you what it does. What it does is it kills a lot of that sovereign citizen shit because it exposes them. You got to expose these people because they are doing deception. Every judge knows the jurisdiction they're operating under. They sitting up there on that bench. They know what's going on, but they're going to play you like they don't. And that's why you have to ask questions. Like, Your Honor, look, man. I'll be more than happy to make an appearance in these matters. However, before I do so, I think we need to address some in personam or in rem jurisdiction questions as it relates to my status before this court, because I believe that this court is operating under a presumption that I have a certain status, all right? And as such, that would subject me to the jurisdiction of this court. So as such, under the authority of the Sixth Amendment for the Constitution of the United States of America, I would like to get some clarification on a couple of things, because it is my understanding that I have a right, a protected right, to know the nature and cause of any action in any court that I appear in. Is that not right, Your Honor? Okay, so what do you want to know? Well, what I'd like to know is this a civil or criminal action? It's a criminal action. Okay, well, thank you. Let the record show that the action being brought against the defendant is a criminal action. Now, sir, I have another question for you. The Constitution for the United States of America only grants this court two criminal jurisdictions. One is under the common law, and I know we're not operating under a common law. You don't have to tell me that. But the other constitutes a condition. Don't say that. No, don't say that. Don't make conclusions. Just say one is under the common law, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Now, sir, for the record, under which two of these jurisdictions is this court trying this criminal action? The reason that you're asking that question is letting them know that, look, okay, it's a cornering question. You can sit up there on that bench and act like you don't know what's going on, but now the Constitution constrains you. That's what it is. It's a restraint. It's handcuffs. So I'm pulling out the handcuffs on you, all right, because I am of the posterity. Okay, you're here to serve us, all right? We don't have no kings or queens in the United States of America. No one is above the law in the United States of America. Okay, so I got to get a couple of questions answered. All right, so what jurisdiction are you operating under? Now, we're here on, it looks like a civil matter because she owes a fine, okay? She had restitution of $4,500. She could come in with a W-9 and ask them for their EIN number because, look, I'd like to report this on my taxes. I'm paying y'all $4,900. That's income to the court. Let me report that. They'll try to say it's not. Okay, well, if it's not, well, let me just still see. I'll take it to my CPA and let them know. But until then, I need some information. These are things you can attack. Come in and attack the taxes on the court. You're going to get more leeway with that, with doing some taxes on this court case. All right. So all that name stuff and everything, don't get caught up in that, because that's just a quick way to spiral out of control and end up in jail or something like that unnecessarily. All right. You can always fight if you're free. But if you get arrested for some bullshit like this right here, it's just going to be much more difficult for you. He's putting you in jail. It's really a contempt right here because you haven't paid it. It's not a charge. This is a contempt proceeding. She don't even need to say, present any argument. She don't even have to. She can just say, look, Your Honor, I didn't have the money to pay it. And then come back and hit them with or come in court and say like this, Your Honor, I have before this court a negotiable instrument. I'd like to satisfy this entire obligation, and I'd like to submit it to the registry of the court. Where do I need to submit this to? Well, what do you mean a promissory note? Well, I have a negotiable instrument, Your Honor, that I have drafted in accordance with Article 3 of the Uniform Commercial Code. And I'd like to tender this for offset and adjustment of this fine that I've been charged with. Well, we only take cash, check, or credit cards. Well, am I to understand the honorable judge is willfully violating public policy? For the record, sir. Because under public policy, you cannot require me to pay with cash, check, or credit card. You can't require me to pay in anything because there ain't no money. So that's just a little suggestion for you. Let's keep watching and see what's going on.